All right, this is people of the state of Michigan versus Demario Ross, docket numbers 21-326FH and 20-727FH. This is the time set for a plea on each of these files. And is everybody ready to proceed? We have 2 defense attorneys and 1 prosecutor.
People are ready, Your Honor.
Defense is ready, Your Honor.
We're ready, Your Honor.
Mr. Ross, I just wanted to ask that since for the record, we had a breakout room where Mr. Ross could consult with both of his lawyers, 1 on each case. Mr. Ross, would you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. Mr. Ross, you have the right to be represented by an attorney. You are represented on this this first file, which is the robbery charge by Mr. Marks, and on the second file by Mr. Feigelson. And Ms. Nelson, could you tell me which counter counts the defendant is pleading to on each file?
Yes, Your Honor. On file 20-727, which is currently charged as a count 1 unarmed robbery, count 2 uttering and publishing, we would be making an oral motion to add a count 3 larceny from the person. And the defendant would be entering the plea as to it relates to count 3, as well as a requested second oral amendment request for a habitual offender third offense notice. On file 21-0326FH, he would be pleading guilty to count 1 child abuse third with a habitual offender fourth offense notice.
Okay, then would you read those charges, please, with the habituals that apply?
Certainly, Your Honor. In file 21-326-FH, the people of the state of Michigan versus Demario Deshawn Ross, state of Michigan, county of Ingham, in the name of the people of the state of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on or around October 6th of 2020 to October 13th of 2020 at 1100 Ramada Drive, city of Lansing, Ingham County, the defendant did in count 1 commit the offense of child abuse third, did knowingly or intentionally cause physical harm to a child, contrary to Michigan law. This is a felony punishable by 2 years or probation for up to 5 years. And additionally, he would be entering that plea as it relates to a habitual offender of fourth offense notice. Take notice that the defendant was previously convicted of 3 or more felonies or attempts to commit felonies, and that on or about April 23rd, he or she was convicted, of 2003, he or she was convicted of the offense of unarmed robbery in violation of Michigan law in the 30th Circuit Court for Ingham County, state of Michigan. And on or about November 25th of 2003, he or she was convicted of the offense of assault with a dangerous weapon in violation of Michigan law in the 30th Circuit Court for Ingham County, state of Michigan. And on or about April 10th of 2004, he or she was convicted of the offense of larceny from the person in violation of Michigan law in the 30th Circuit Court for Ingham County, state of Michigan. And on or about June 21st of 2017, he or she was convicted of the offense of assault with a dangerous weapon in violation of Michigan law in the 30th Circuit Court for Ingham County, state of Michigan. Therefore, the defendant is subject to the penalties provided by MCL 769.12. The penalty is a life if primary offense has a penalty of 5 years or more, 15 years or less if the primary offense has a penalty under 5 years. And the maximum penalty cannot be less than the minimum term for a first conviction. Court shall order law enforcement to collect a DNA identification profile sample before sentencing or disposition, if not taken at the time of arrest. This offense was committed against the peace and dignity of the state of Michigan. And just a minute, if I may. In file 20-272-FH, people of the state of Michigan versus Demario Ross, state of Michigan, county of Ingham, in the name of the people of the state of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on or about February 8th of 2020 at 1826 South Cedar Street, City of Lansing, Ingham County, the defendant did in an added count 3 commit the offense of larceny from the person, did commit the offense of larceny by stealing from the person of another, to wit, Heather Scott, certain property, to wit, an Xbox, contrary to Michigan law. This is a felony punishable by 10 years. In addition to that, Your Honor, the offender would be sentenced as a habitual offender. Third offense noted, again, an added amendment to this information. Take notice that the defendant was previously convicted of 2 or more felonies or attempts to commit felonies. In that on or about June 11th, 2003, he or she was convicted of the offense of unarmed robbery in violation of Michigan law in the 30th Circuit Court for Ingham County, State of Michigan. On or about June 2nd of 2004, he or she was convicted of the offense of larceny from a person in violation of Michigan law in the 30th Circuit Court for Ingham County, State of Michigan. On or about June 21st of 2017, he or she was convicted of the offense of delivery, manufacturing heroin or cocaine in violation of Michigan law in the 30th Circuit Court for Ingham County, State of Michigan. Therefore, the defendant is subject to felonies provided by MCL 769.11. The penalty is twice the maximum sentence on a primary offense or a lesser term. The maximum penalty cannot be less than the maximum term for a first conviction. And this offense was committed against the peace and dignity of the state of Michigan.
Mr. Ross, you're being charged here in the first file with larceny from a person. That is a felony. And because the prosecutor is proceeding against you as a habitual third offender, it makes the maximum penalty up to 20 years in prison. On the second file, you're being charged with third-degree child abuse. That is a felony punishable because the prosecutor is proceeding against you as a habitual fourth offender. It's punishable by up to 15 years in prison. In addition, if you were on parole when you committed either of these offenses, there would be a mandatory consecutive sentence. Have you had enough time now to talk about these charges with your attorneys, Mr. Ross?
Yes, ma'am.
And do you understand the charges against you?
Yes, ma'am.
Do you have any questions about what we're doing today?
No, ma'am.
How do you want to plead?
Guilty on both charges, Your Honor.
Thank you. If your plea of guilty is accepted by this court, it means you won't have a trial of any kind, and you'll be giving up the rights that go along with the trial. I'm going to go through those with you. You have the right to a trial by jury. If you didn't want a trial by jury, you could have a trial by judge. You have the right to be presumed innocent until proven guilty, and the right to require the prosecutor to prove your guilt beyond a reasonable doubt. You have the right to have the witnesses against you appear at the trial and to be able to cross-examine them, as well as the right to have this court order any witnesses that you might have to appear at the trial. You have the right to remain silent at the trial and not to have your silence used against you, or in the alternative, to testify at the trial if you wanted to. There are also 2 things about appeals that are different when you plead guilty. The first is that you don't get an automatic right to take your case to the next higher court and have them look at it. Instead, you have to ask them to look at it. They would have to agree. And the other thing that's different is that when you plead guilty, there are many issues you cannot appeal, where people who go to trial, if they get convicted, they can appeal pretty much everything. Do you understand those rights, Mr. Ross?
Yes, ma'am, I do.
Also, if I accept your plea, it means you can't come back later on and try to say that the plea was the result of some promise or threat that no one told me about today. Do you understand that?
Yes, ma'am.
Also, you can't come back later on and try to say that it really wasn't your own choice to plead guilty today. Do you understand that?
I do, Your Honor.
Is there a plea agreement, Ms. Nelson?
Yes, Your Honor. The defendant will plead guilty on file 20-727-FH to the added count 3 of larceny from a person, as well as with the sentencing notice of a habitual third offender. The defendant will also plead guilty in file 21-326-FH to count 1 child abuse in the 3rd degree as a habitual 4th offender. There's a sentencing agreement pursuant to People v. Killebrew. The parties agree that any upfront jail will not exceed 12 months in the Ingham County Jail, and that the sentences on both of these files will run concurrently with one another. Additionally, the defendant agrees to restitution on the original charges on both files, if there were to be any.
And the people agree that they're dismissing counts 1 and 2 on docket number 20-727.
Yes,
And
Your
they're
Honor.
dismissing counts 2 and 3 on docket 21-326.
Correct, Your Honor.
Okay, is that a full and complete statement, Mr. Feigelson?
Yes, Your Honor.
Mr. Marks?
May it please the court, it is, Your Honor. Also, defense has no objection as far as to the amended information.
Okay, and Mr. Ross, is all of that your understanding of the agreement as well?
Yes, ma'am.
Do you agree with it?
Yes, ma'am.
There is an agreement about your sentence, and that is that your upfront time would be no more than 1 year in jail. If for some reason I decided not to go along with that, I would tell you before I sentenced you, and I'd give you a chance, if you wanted to take back your plea and start over. You got all of that?
Yes, ma'am, I do.
Okay. Has anyone promised you anything else that has not been said right now in order to get you to plead guilty?
No, ma'am, they haven't, ma'am.
Has anyone used any threats to get you to plead guilty?
No, ma'am.
Is it your own choice to do this?
Yes, ma'am, it is.
And are you doing it because you believe you are in fact guilty of these offenses?
Yes, ma'am.
Okay, let's start then with the larceny from a person. Tell me what you did on or about February 8th of 2020.
I met the young lady at a corner store in agreement to buy a video game from her. Whereas I ended up just snatching the bag from her and walked away from the scene.
Okay, so you met up with her under the plan that you were going to buy it, but you just grabbed it from her and took it?
Yes, ma'am.
Okay, and that was Xbox?
Yes, ma'am, it was.
And did you have to physically grab it from her hands?
It was sitting on the car, and on the car, and after she set it down, I picked it up in my possession, and yes, ma'am.
Was it very nearby where she was?
It was pretty much close to it, yes, ma'am.
Okay, so you forcefully grabbed this right from her presence, is that correct?
Yes, ma'am, indeed.
Okay, and that was at 1826 South Cedar Street in Lansing, Ingham County?
Yes, ma'am, it was.
Okay, and then let's turn to the other file, and this is between the dates of October 6th of 2020 and January 20th of 2021. Tell me what you, or actually strike that. Count 1 is between October 6th and October 13th of 2020. Tell me what you did there.
I was called to discipline my son, and I ended up using a little bit more excessive force than usual based off the severity of him hitting his sister in the face. Regardless of the fact of him hitting her, I used it entirely a little bit too much force on him. And
Did you cause a physical injury?
I caused a bruise on his arm. Yes, ma'am, I did.
Okay, and you agree that was excessive force beyond normal?
That was a little bit more excessive than I usually carry.
Okay, and how old was your son at the time?
At the time, he was 6.
6, okay. And did that happen at 1100 Ramada Drive in Lansing, Ingham County?
Yes, ma'am.
And you intentionally caused the bruise? In other words, it was not an accident, correct?
Indeed, ma'am.
Okay. Has the court complied with MCR 6.302? Mr. Marks?
It has, Your Honor.
Mr. Feigelson?
It has, Your Honor.
Ms. Nelson?
Your Honor, may I follow up with one question on the larceny from a person?
Sure.
Mr. Ross, at the time that you took the property, did you intend to not give that back to the property owner, Ms. Scott?
Yes, ma'am.
Your Honor, the people are satisfied that the court has complied. Thank you.
Thank you. Are you aware of any promises, threats, or inducements other than those already placed on the record, Ms. Nelson?
No, Your Honor.
Mr. Marks?
No, Your Honor.
Mr. Feigelson?
No, Your Honor.
The court finds the plea is understandingly and voluntarily made without undue influence, threats, or promises of leniency. It is an accurate plea. It's supported by the testimony. The pleas are accepted. And I have a sentencing date of Monday, September 13th at 3:45.
I can make that work, Your Honor.
Okay, Mr. Marks?
That is going to be totally upon Mr. Feigelson to handle because I will no longer be employed.
Oh, no.
My last day is September 3rd.
Oh, my goodness. That is sad for us, not for you, I'm sure. So, Mr. Feigelson, you're going to handle both the cases? Is that what happens?
I believe so. Just given the circumstance, I still have to check with Mr. Church, but I believe that's what the plan's going to be.
Okay. Mr. Ross, is it okay with you if we just do the sentencing remotely from the jail instead of bringing you to the courthouse?
Yes, ma'am. I was under the impression that we could have got it done right now.
Not sentencing, no. Actually, you're going to get contacted by someone from adult probation, and they're going to interview you. They do a whole report that tells me more about you and everything. So you should just be aware that they're coming, and that's why the sentencing date is a little bit far out, because they need that amount of time in order to prepare the report. Okay, do you have any other questions, Mr. Ross?
No, ma'am.
Okay, then we're all set. You can tell them at the jail there that you're done with your hearing.